Good morning, everybody. Yes, let us start the proceedings.
From daily cost list under the heading for orders, serial number 1, MA number 3302 of 16, Mr. DC Ghosh for the appellant, Mr. Madhav Prasad, Mr. Jitendra Tripathi for the respondent.
Yes, Mr.
Well, due to inadvertence, I have not complied the last order. No, for complying the same alert, some time may be granted. My lord. Last order dated 14/10/19. Regarding the heirs of respondent number 6, others are already on record.
The years are already on record.
Yes, my lord, yes. And regarding 7, I have to file the requisite of notices as per the last order. Sometime.
Counsel for the appellant, Mr. Devesh Ghosh submits that the name of respondent number 6 needs to be deleted. So he submits that he will take steps for issuance of he will take steps and file requisites so that notice can be served upon respondent number 7. Full stop. They are allowed notice by ordinary process.
My lord.
Notice by ordinary process within 3 weeks.
Serial number 2, MA number 318 of 16, Mr. Sudhanshu Kumar Dev for the appellant.
May I please, Your Lordship?
Yes.
My Lord, kindly seen the last order 3/2/2020, my Lord. Earlier notices issued to the respondent number 1 to 6, my Lord. Notice has filed within time, my Lord. And subsequently, last order 3rd February 2020, kindly peruse.
I am appearing on behalf of respondent number 1, Your Lordship, insurance company.
Fresh notice to respondent number 2 in his correct and present address. Full stop. Notice to respondent number 3 to 6. Full stop. Requisites in all the cases by ordinary process within 3 weeks.
Fresh step taken, my Lord.
Yes.
Ordinary process.
Yes.
Oblige, my Lord. Oblige.
MA number 375 of 16, Mr. DC Jha.
In this case, respondent are 1 to 6, 1 to 5 are the claimants.
You
They
have
have
not
put
filed
the
requisites. You have not filed requisites.
claimant number
5 has appeared.
1 to 5 has appeared, Your Lordship.
Who is respondent number 1 to 5? Who is appearing, Mr. Lal?
Yes, my lord. My lord. My lord.
What is this matter about?
This is related to permit, Your Lordship. So the owner of the vehicle is necessary.
Owner of the vehicle is respondent number 6.
Yes, Lord.
Perhaps liberty has been given to realize.
So, but where is respondent number 5? Is anyone appearing? Anyone appearing on respondent number 6?
No, your lordship.
Earlier notices were issued. Perhaps it hasn't properly served or not.
There is no office report.
Fresh notice on respondent 6, your lordship.
Fresh notice, respondent number 6, ordinary process.
Okay.
Serial number 4, MA number 409 of 16. Mr. P.K. Mukhopadhyay and Mr. Ashish Kumar for the appellant.
My lord, I appear in this case on behalf of Railway, my lord.
This for the appellants. Railway. Oh. Yes. Who is appearing? Mr. P.K. Mukhopadhyay, Mr. Ashish Kumar.
My lord, he appeared.
My lord,
Yes, Mr. Mukhopadhyay.
my lord. My lord, I am appearing. My lord, serial number 4, my lord.
Yes, it is serial number 4.
My lord,
Yes.
my lord. My lord, I am appearing on behalf of the appellant, my lord.
Yes.
My lord,
Yes.
in this case, my lord, counter affidavit has been filed by the respondent number 1 and 2.
Respondent number 1 has not appeared through Wakalat.
1 and 2 has filed, my lord. Counter affidavit has been filed on behalf of respondent number 1 and 2.
Where is the Wakalatnama of respondent number 1?
My lord, he cannot be made by name party, my lord, because the vehicle belongs to the railway department, sectional officer.
So he has been made a party by name. He is a party as a take.
My lord, but the vehicle belongs to railway.
Mr. Counsel, vehicle belongs to whom I don't know. I'm not adjudicating that issue now.
My lord,
As on date, there are 2 respondents.
my lord.
Wakalatama is only on behalf of respondent number 2. If you want deletion of respondent number 1, let a petition come. Otherwise, there has to be appearance. It is the claimant who has filed this case and they have impeded him as a respondent.
But then I will file, my lord, a petition, my lord, for deletion of his name.
Whether he will file or the appellant will file, it is up to you.
It would be proper if the appellant file and delete the name only. He may be implicated as part on designation, my lord, on the basis of designation.
Yes, Mr. Mukhopadhyay.
My lord. My lord, that is the position, but they had to pay the awarded amount as well as I have paid for my lord, enhancement of the amount. So
You complete the appearance, let the appearance, you should fresh notice to respondent number 2 by registered, covered and ordinary, respondent number 1 by registered, covered and ordinary process. Requisites 2 weeks.
but my lord, one thing, but the respondent number 1 was the employee of the railway department, and now railway department has already has come forward. Therefore, my lord, they will But whatever liability is fashioned on number one, that's
Mr. Mukhopadhyay, Mr. Mukhopadhyay, you have made a person by name a party as respondent number one. Once you have made him, let him appear.
yes, ma'am. Then I'll file
Yes, next.
2 weeks.
Milord, serial number one. Milord, serial number one. Some technical problem. I am late. I am appearing on the behalf of petitioner. My senior is.
Wait, there's a proceeding in this procedure which this court follows. Please follow the procedure.
Serial number 5, MN number
But
4.
week time may be granted. Like number 4.
3 weeks का दीजिए Mr. Mukhopadhyay. Yes.
Lordship, in this case, last date, awaiting service report of respondent number 8.
Respondent number
8.
8.
Milord, serial number one. Serial number one, Milord.
Why are you interfering? When a proceeding, when a matter has been called, why are you interfering? If you have not appeared, and you wait for your turn. When I finish the order cases, the passover cases will be called out if at all it is passed over. This is the procedure which this court follows. Everyone knows it. And serial number 1 is, it is your appeal. Is it your appeal, serial number 1?
Serial number 1, I am appearing for the appellant.
This is appearing on behalf of the appellant.
This is appearing for the appellant.
Which case you are appearing? Which case you are appearing, Mr. Counsel? Mr. Tripathi? What is your case number? Unmute yourself. Unmute yourself. Unmute yourself.
Okay.
Yes, Mr. Tripathi, in which case you are appearing?
302/16.
It is Mr. Devesh Ghosh is appearing. He is the appellant. Mr. Dishi Ghosh.
Okay. Okay.
You are on behalf of whom? You are on behalf of whom? You also don't know you are on behalf, you are representing whom? You are representing whom? Which party?
Asa Devi.
You are the respondent.
Okay. Okay. Asa Devi is the respondent. Okay.
Yes.
Lordship, last date, awaiting service report of respondent number 8, Lordship.
Yes.
Sir.
No one has appeared. Fresh steps. Fresh steps. Ordinary process requisites 3 weeks upon respondent number 8.
Lordship.
Serial number 6, MN number 452 of 16, Mr. Alok Lal for the appellant. Mr. Party for the respondent.
Lordship, in this case, I am filing for IA for substitution of respondent number 2.
Where is your IA? Where is your IA?
IA filed on 24/2/2020.
24/2/2020. Yes. IA number 2092 of 2020. This IA has been filed to substitute to the deceased respondent number 2. Who died leaving behind his son, his 2 sons, namely so and so, paragraph 4. As the right to sue survives. devolves upon the legal heirs in this so and so. This IA is allowed. The applicant is directed to make necessary correction in the cost title and delete the name of respondent number 2 and substitute him by the legal heirs. Namely, so and so. IA stands allowed. Next up, issue notice to the respondent number 2, the legal heirs newly added respondent number 2, 2 and 2A and 2B. Yes, requisites ordinary process, 3 weeks.
Your Lordship, I'm appearing in behalf of respondent number 1, Your Lordship.
Okay. You send your slip.
Okay, Your Lordship.
Serial number 7, MN number 463 of 16. Mr. Manish Kumar, Mr. Abhishek Mishra, Mr. Rajesh Kumar Singh for the appellant, Mr. Anjali Kumar for the respondent.
May I please, my lord, there are two IAs, my lord. One is for deleting the name of respondent number 6.
That is IA number?
IA number 2746 of 2019, my lords.
Okay, IA number 2476 of 2019. This application has been filed to delete the name of respondent number 6, who died during pendency of this appeal. Good stuff. Considering the interlocutory application, let name of respondent number 6 be deleted. IA stands allowed. Yes, what is the next one?
Say next one is IA number 7759 for stay of execution proceeding, my lord. We are ready to abide by any condition, my lords. Because it is a case of gratuitous passenger, my lord, so at best we will get right of recovery. So we will pay the entire amount, my lord.
Pay the amount.
My lord,
IA number, I'm dismissing it. IA number 7759 of 2019.
my lords, may I know why, my lord, I pray, my lords. It is pending, my lord, since long, my lords, since COVID was there, my lords.
No, I am dismissing it because at best you can get a right to recovery. Pay it, it will be recovered. I'll be holding that.
My lords will kindly, what is happening, my lords? We cannot, my lords, say that we deposit insurance company, my lords, officers are there, my lords. My lords will observe that I will deposit the entire awarded amount, my lords. I'll deposit, I'm not saying that I'll deposit half of the amount. I'll comply.
Keep the entire amount. Keep the entire amount with you.
Yes, no, I'll give entire amount along with interest, my lords. This is what I'm saying, my lord. My lords, एक लाइन मेरा सुन लिया जाए, my lord, एक लाइन हम लोग का कोई
I'll hear you for 1 hour. Tell me.
No need to hear me for 1 hour. हम उतना देर बहस भी नहीं कर पाएंगे. मेरा बात खाली सुना जाना. हम थोड़ी बोल रहे हैं कि हम आधा करेंगे, नहीं करेंगे. हम तो कुछ नहीं बोल रहे. हम तो क्वांटम चैलेंज भी नहीं किया.
Just a minute. Why do you want a stay? Tell me.
Well, so that execution proceeding खत्म हो जाएगा.
What are the basics of a stay?
Well, stay है कि ठीक है वो what my lords you are observing is correct, my lords. Once the entire amount is deposited, there is no question of any execution proceeding stand anything. Execution proceeding itself will come to an end.
No. Once once you deposit the entire amount, that doesn't mean that the execution proceeding will come to an end. That is a different aspect. But once you deposit the entire amount, you want your interest to be protected.
My lord.
Where I see that you will get refund of money or the quantum is so excessive that if the execution case is allowed or if you're directed to pay the amount, it will be impossible for you to recover the amount
My lords will try to appreciate one thing. Yes, I understand, my lords. One thing only.
In this case, when I see that at best you can get a right to recovery from the owner, then why should I deprive the claimants from getting the fruit of this?
No, I want that it should be disbursed. हम नहीं बोल रहे disburse करवा दिया जाए. हम तो वो बोल रहे हैं. नहीं, my lords will kindly appreciate. बाद में क्या हो जाता है माय लॉर्ड, बहुत सारा वकालत में ऐसा भी लोग बहस करता है कि वंस वी हैव सेटिस्फाइड द अवार्ड नो केस दिस सो मेनी कॉम्प्लिकेशंस आर देयर। हम तो बोल रहे हैं डिपॉजिट करके डिसबर्स करवा दिया जाए। माय लॉर्ड हम तो कभी बोल नहीं रहे हैं माय लॉर्ड कि हम खाली जमा कर देते हैं, हम तो बोल रहे हैं उसको डिसबर्स कर दिया जाए माय लॉर्ड। माय लॉर्ड
So I have to disperse this, Mr. Manish, get the order first.
ठीक ठीक।
For disbursing is also I have to dismiss this IA application.
नहीं अलाउ करके आप बोल सकते हैं माय लॉर्ड कि इसको जमा किया जाए, वी शैल बी डिसबर्स।
Allowance what? Allowance stay of the execution proceeding.
हाँ फिर बाद में हो जाएगा माय लॉर्ड। फिर काइंडली अप्रिशिएट कि आप पैसा दे दिए हैं। फिर
this IA has been filed to stay the execution proceeding, being execution case number
2 of 2019
pending in the court of
my lord principal district judge come city
Singhu West at Chaivasa. By moving this application, the counsel appearing on behalf of the appellant submits that he has challenged the decree award, and if he is forced to satisfy the said award, it will be very difficult for the appellant to recover the money in case this appeal is answered in favor of the appellant insurance company. On this ground, he prays to stay the operation, the further proceedings of execution case number 2 of 19 pending before so and so. Next paragraph. After hearing the counsel for the appellant and after going through the record and the impugned judgment, I find that the insurance company has taken a plea that the deceased was a gratuitous passenger, and thus they are not, and thus there was a violation of the policy, and the owner is liable. Thus, the owner is liable to pay the entire amount of compensation. Full stop. Next paragraph. From the argument and from the nature of the award, I find that even if this appeal stands allowed, the best relief which can be granted to the insurance company is a direction that the insurance company is entitled to recover the said amount from the owner of the vehicle. Full stop. In that event, it will not be proper to deprive the claimants the fruit of the decree, fruit of the award which is in their favor. Full stop. Thus, no useful purpose would be served in staying the execution case. Full stop. The insurance company is directed to comply the award, subject to the final order which would be passed in this appeal.
Yes.
Besides,
obliged.
Obliged. Lordship, I am on behalf of claimant. Lordship.
May I pray one thing, my lords? Since the notices have been validly served upon all the respondents, my lords.
Yes.
The case may be listed for admission, my lords, after any 4 weeks, 3 weeks, whatever is my lords.
Main case will list this case under the heading for admission.
My lord. Obliged.
Lordship, may I appearance will be noted, Lordship, for the claimant.
Give you a slip, it will be noted. If you don't give a slip, it will not be noted. Yes.
Obliged, Lordship.
Serial number 8, coming number 511 of 60, Mr. Sachidanand Lal, for the appellant, Mr. Santosh Kumar, for the respondent.
Anyone appearing in this case? Both has expired. Anyone appearing?
Lordship, in this case, my name is appear on behalf of respondent insurance company, Lordship. But
It has been
Mr. Asutosh Anand will argue in this case, Lordship. Company has deputed Mr. Asutosh Anand on behalf of future generation.
It has been informed that both the learned advocates appearing on behalf of the appellant, that is Mr. S. N. Lal and Rajiv Anand, has expired. Has unfortunately expired. Full stop. Next, issue notice to the claimant appellants. The office is directed to issue notice to the appellants informing the aforesaid fact and intimating them to appear through another lawyer. Full stop. Next para. Member Secretary Chalsa is also directed to don't trade Member Secretary. Likhi Chalsa is also directed to contact the appellants and inform the aforesaid status and will inquire as to whether the appellants need legal assistance or not. Full stop. If the appellant needs any legal assistance, the same should be extended to them by Jalsa. Then a copy of this order also be communicated along with the cost title of this petition be communicated to Jalsa.
Serial number 9, MA number 513 of 16, Mr. Sudhir Kumar Sharma for the appellant.
My lord, in this case, my lord, on 17th of September 2018, my lord, the appeal was admitted and the notices were issued, my lord. We have filed requisites, my lord.
Respondent number 1, you have to take fresh steps.
Right.
Fresh steps upon respondent number 1, its correct and present address, requisites 4 weeks ordinary process.
My lord, in this case, my lord, records has not been called for, my lord, as it is apparent from the order. Your lordship may call for the record.
Let me see.
Seventeen 9/2018.
Mr. Sharma, just a
My
minute.
lord.
Is there any order to recover the amount from the claimants, from the owner?
My lord, as such, there is no order, my lord.
So this appeal, you are not claiming any relief against respondent number 1.
No, my lord. The direction is for respondent number 2. I may be permitted to read the impugn order, my lord.
Just a minute. You need not take steps for notice. Okay? The no relief has been sought for in this appeal against respondent number 1. So thus, this court feels that at this stage, no notice need be issued to respondent number 1. No further notice be sent to respondent. Full stop. Next para, call for the low court record.
My lord, respondent number 2 is also perhaps not appearing. Nobody name is appearing. If your lordship will direct, I may serve the copies.
Serve a copy. Counsel for the appellant will serve 2 copies of this memo of appeal upon counsel who appears on behalf of respondent number 2.
The National Insurance Company.
Yes, serve it on Manish Kumar. Is there? Yes, next.
Serve copies to whom, my lord?
Any
To
lawyer,
whom, my lord?
any lawyer who appears in respondent number 2.
Oblige, your lordship. Oblige.
Yes, next.
Serial number 10, MA number 535 of 16.
My lord, so far as IA number 1263 of 2018 is concerned, that has become infructuous because the execution proceeding proceeded. We had deposited the entire amount.
Mr. Amit Das, appearing on behalf of the appellant, submits that IA number 1263 of 2018 has been rendered infructuous as the entire amount has been deposited. Full stop. Yes, what is the main appeal?
Lordship, main appeal, the only ground which survives is, your lordships, that despite challenge, the owner did not appear, did not produce any vehicular documents. The learned court below, lordships, gave a liberty that you may file a fresh suit for recovery of the amount. Lordship, following that Satpal judgment, which has subsequently been overruled.
Yes.
The law is settled that right to recovery has to be decided by the court and
Decided by the tribunal itself.
tribunal itself.
Uh, issue notice to respondent number
The owner will be respondent number
5.
Yes.
Ordinary registered, requisites 3 weeks. First up, call for the lower court records.
obliged, Your Lordships. Perhaps notices were already issued on 6/3/2018. I'm not aware whether it has been served.
Respondent number 5 in proper and correct address.
Obliged, Your Lordships.
Serial number 11, MA number 543 of 16.
Wait,
From Monday.
wait, please. My lords, in this matter, notices were issued on 21/10/2019. I'm made to understand that the requisites have apparently not been filed. I'll just check with them. And for the respondent insurance company, Mr. Manish Kumar has to appear. His name is not appearing. He had accepted notice as per order dated. Order dated 21/10/2019.
The notice is incomplete. You go through the office note. You have not annexed
Yes,
a copy
madam.
to the limitation
Yes,
application.
madam.
This case after 3 weeks. The counsel for the applicant will comply the office directions.
Obliged, madam.
Serial number 12, MA number 552 of 16. Mr. K.L. Oja. For the appellant.
Yes.
In this behalf of the IM appellant, there is a IA matter pending before you, my lord. IA number 9539/17.
There is a problem with the notice.
That is filed for the early hearing on the basis of the ground, merit ground.
Who is respondent number 2?
Your Lordship, perhaps I am appearing for claimants, Your Lordship. Claimants respondent number 1. Perhaps respondent number 2 is being appeared by Nikhil Kumar Mehta.
Owner.
Owner, yes, Lordship.
Who is appearing?
Perhaps Mr. Nikhil Kumar Mehta is appearing. His name is.
What is your ground for this appeal?
This IA is demanding for on the basis the merit ground hearing, my lord.
May I state the brief facts, my lord, with Your Lordship permission?
Just a minute. What about there's a notice to respondent number 1?
I am for respondent number 1, Mantu Viskarma, my lord.
You are the claimant. But what about respondent number 2?
My lord, perhaps Mr. Nikhil Kumar Mehta is appearing for respondent number 2, my lord. He must have filed. His name is appearing in the cause list.
His name is appearing in the cause list. Nikhil Kumar Mehta. Who is Nikhil Kumar Mehta? He's your associate.
Oh.
He's your associate. It is the same Wakalatama which you have filed.
Lord, Then he must have filed.
Also, you don't even know who is
One
your
is not
associate.
appearing. One is not appearing. Two is not appearing. Two is not appearing.
Fresh notice to respondent number 2 in its correct and present address requisites 3 weeks ordinary process.
My lord would find that there is no right of recovery or in this. It is on the case is on a different footing, my lord.
We'll see to it.
Serial number 13, MN number 561 of 16, Mr. Manish Kumar, Mr. Amit Mishra. For the appellant, Mr. Amit Sahai, Mr. Rishi Raj Verma, for the respondent.
My lords, it was directed to be listed under the heading for admission, my lords, but it is listed under the heading for orders.
Your Lordship, I'm here for respondent number 6 and 7. Sure.
The amount has been deposited?
Yes, my lords. 5 lakh rupee was deposited.
It was withdrawn?
Yes, my lord.
What is this appeal?
Appeal is on the ground that, my lords, the owner of the motorcycle did not produce the driving license of the driver despite, my lords, a specific statement given by the insurance company. They appeared and filed written statement but did not, my lords, take any step to file the copy of the driving license. The case is covered by, my lords, Pappu versus Vinod Kumar Lamba.
So, what are the 2 vehicles which was involved?
My lords, the 2 vehicles were, my lords, bicycle and motorcycle. Deceased was going on bicycle, my lords, and he was dashed by motorcycle. The owner of the motorcycle appeared, filed his written statement, contested the case, but despite there being specific stand by the insurance company that the driver was not in possession of valid and effective driving license, the driving license was not filed.
Who appeals for the owner?
My lords, name just now, one lady advocate was appearing, my lords, for respondent number 6 and 7. 6 is the, my lords.
Your Lordship, I'm appearing, Your Lordship.
Yes.
Yes.
For respondent number 6 and 7.
Yes. Tell me, what do you have to say?
Your Lordship, we haven't received any kind of instruction from them, Your Lordship.
What do you mean that we have not received any instructions when you have already filed a wakalatnama? You have filed wakalatnama. Are you sure you are appearing in this case?
Indeed, Your Lordship.
Yes, you are appearing. When you have filed wakalatnama on behalf of a particular party, then does it look good to say that I have not received any instruction?
Your Lordship, we have tried contacting them.
What do you have tried? Instructions are passed on immediately when the wakalatnama is handed over to you.
Your Lordship will file the reply, Your Lordship.
What reply? This is an appeal. Where is the question of reply? This is an appeal, a statutory appeal. Where is the question of a reply or a counter affidavit? Can you bring in any fact why a counter affidavit is filed? What is the purpose of filing a counter affidavit? To controvert fact only. This is an appeal. It has to be decided on the basis of the documents which is already there on record. That is the
Indeed,
question. Where is the scope of filing a counter affidavit or a reply? Take down. The parties have appeared. List this case under the heading for admission. LCR is here.
No, my lord.
Call for the low court records immediately. And let's discuss the possible. Take down if possible. The case can be disposed. This appeal can be disposed of at the stage of admission itself. The party should be ready for hearing, for disposal. Yes, next.
Number 14, number 565 of 16, Mr. Arvind Kumar Lal for the appellant. Mr.
My lord, I am for the appellant. It is for enhancement of the awarded amount of compensation. I am not aware why it has come under the heading orders, my lord.
I am also not aware.
Your Lordship, I am appearing for respondent number 1 and respondent number 2, Your Lordship.
Here is here. Well, this is under the heading for orders. Yes. This case has been wrongly listed under the heading for orders. Stop. Unless this case under the heading for admission.
Next week, my lord.
Next week. Next week.
Good.
Number 15, MA number 568 of 16, Mr. Arvind Kumar Sinha for the appellant. Mr. Manish Kumar, Mr. Chinto Sen for the respondent.
Appearing on behalf of appellant, Your Lordship, in this case. On 7/11.
Anyone appearing on behalf of respondent number 6?
But I am appearing on respondent number 7, New India.
Yes, but who is for respondent number 6?
I am appearing on behalf of respondent number 1 to 5, Lordship.
So you are for the claimants?
Yes, Lordship, I am for the claimants.
What is for the insurance company? You are representing, madam?
Your Lordship, I am on behalf of appellant, Your Lordship.
Who are you?
The owner of the truck, Your Lordship.
Okay. That means respondent number 7 is B6 is the driver.
Yes, Your Lordship, he is driver.
So what is your prayer in this case? What is the ground? What is the ground?
Your Lordship, Mr. Anil Kumar Sinha will argue this case and he is out of station, Your Lordship. This case comes under the heading of orders, Your Lordship, and that's why I'm appearing.
No, since no relief has been sought for against respondent number 6, at this stage, it's not necessary to issue fresh notice to respondent number 6. Full stop. Next para. LCR is here in this case. Huh? Call for the lower court records and keep this and list this case under the hearing for admission.
Obliged, Your Lordship.
Number 16, MA number 575 of 16, Mr. DC Jha of the appellant.
Notice has been issued on respondent 1, 2, 3. 1 and 2 has appeared, and first notice is required to respondent. Yes, it was not filed.
Your order. Because the order dated 18/1/2020 has not been complied by the appellant. Full stop. Next para. Mr. GC phrase for 2 weeks time to comply the order.
Yes,
They are allowed. Full stop.
Number 17, MA number 582 of 16.
This case has come, my lord, for hearing on IA, my lord, for vacating the stay, my lord, that the part of the amount has been stayed by this honorable court in absence of the respondents 1, 2. We are appearing for the claimants. But annex IA number 319 of 2020 or your lordship may fix this for
लॉर्डशिप इसको एडमिशन में रख दिया जाए, ये हियरिंग हो जाएगा.
It is a
Both the
case, my lord,
both the parties pray that this appeal can be disposed of at the stage of admission itself. Full stop. Lower court record is here or not?
yes, yes, my lord.
The lower court record has also been received. Next line. The lower court record has also been received. Full stop. Next line. Considering the aforesaid fact, let this appeal be listed under the heading for admission after 1 week.
Serial number 18 with serial number 19, MA number 589 of 16 with CO 4 of 20. Mr. Vibhas Sinha, appellant in first case. Mr. Arvind Kumar in first case. Mr. Arvind Kumar Lal, appellant in first case. Second case, Mr. Vibhas Sinha, respondent in second case.
Yes, I am appellant in miscellaneous appeal number 589 of 2016, filed by the appellant insurance company, and the cross objection is filed by the claimants.
Why this is under the heading for orders?
As the notices were issued, it seems that the claimants have appeared, but so far as the owner is concerned,
4 is dead.
3 and 4.
Respondent number 4 is dead.
That's 4 is dead is Nitin Mishra, the owner of the vehicle. Just a second, my lords. He's not probably the owner of the vehicle. He was the person, Nalin Prashad Singh. Nalin, yes, he was the owner of the vehicle, Nitin Mishra.
So,
Nalin Mishra. But my lords, so far as the owner is concerned, I'm just verifying. My lords, by giving 1 minute time.
Yes, my lord.
Nitin Mishra, respondent number 4. He was the owner of the vehicle. So I have to file substitution because I am praying for a right to recovery.
clear. Who is respondent number 3? Mr. Sinha, who is respondent number 3?
Respondent number 3 is the person who was driving that motorcycle. Now, the fact of this case is the deceased has taken the motorcycle which was not registered at that point of time and belongs to respondent number 4. He was traveling with his uncle, who is respondent number 3. That unregistered vehicle met with an accident, and therefore the respondent number 3, being the driver of that motorcycle, was implemented, and respondent number 4 is the owner.
It has been reported that respondent number 4 is dead. Full stop. Next para. And the notice which was issued to respondent number 3 was not served and has been returned with a note that respondent number 3 doesn't reside in the address mentioned in the notice. Next para. Fresh steps for issuance of notice on correct and present address. Full stop. Requisites 4 weeks. Upon respondent number 3, requisite 4 weeks. Full stop.
And it's 4 weeks for filing IA for substitution.
Can I grant you any time to file a substitution application? Can this court grant you?
No, I am praying. I am praying for 4 weeks time for filing appropriate application.
Can I grant you that time? Can I grant you that time? As per law, can I grant you in this? Can I grant you this time?
Technically not.
Legally,
from the date of knowledge,
my only power is to condone the delay and set aside.
Yes, that knowledge is absolutely.
My only power is to condone the delay and set aside the abatements.
Yes.
Nothing else.
Yes, yes, ma'am.
So don't make this type of prayer, at least in this court.
My presence may kindly be recorded, my lord.
Give your slips. Send your slips.
My lord.
Mr. Arvind Lal, remove the defects of the CO.
My lord.
CO pass and write the order in the cross objection. The defects to be removed within 4 weeks.
Obligements.
Serial number 20, MA number 598 of 16, Mr. Alok Lal. For the appellant, Mr. Ajit Kumar Sethi, Mr. Dr. Prasad, for the respondent.
In this case, Lord, I am appearing for the claimant, my lord, who lost his leg, my lord, which has been imputed, and the sum of this 4,05,000 has been awarded.
It is for the
Lordship,
orders.
that notices were issued to the respondent, but service report, Lordship, I am not aware.
But I am appearing for the one, and so far the others are concerned notices. The other lawyers are also appearing.
Mr. Sani, you are appearing on behalf of 1 and 2. 1 and 2.
Yes, from claimant, my lord, claimant. One is.
My lord, I am appearing on behalf of OP number 1.
Bhimdas. Bhimdas is OP number 1, who is claimant. I am appearing for him.
And now someone who said that who is appearing.
Dusra, Manoj Kumar Bhagat must pull my
Yes, my lord. I am appearing on behalf of OP number 1, my lord. Nothing against me in tribunal order or nor any allegation against me by the appellant, my lord. I am only formal.
Mr. Counsel, you are appearing on behalf of most probably the owner, the OP number 2.
OP number 2. He is OP number 2. He is wrongly saying OP number 1.
You are appearing on behalf of opposite party number 2, Mahbub Hassan.
He is the owner.
Now 3 is dead. Who is 3?
My lord, the driver.
No, Lordship, 3 is the another owner, Lordship.
Another owner of the truck. Another owner of the truck, the WB2223A 4446.
4 and 5?
4 and insurance.
4 and 5 driver of the
Driver.
Yes, one respondent number 4 and 5 has been received by father and son respectively. Full stop. This notice is validly served. Full stop. It has been reported that respondent number 3 is dead. Full stop. This case yes, Mr. Counsel, respondent number 3 is dead. Full stop.
I will file substitution.
John. Yes.
Serial number 21, MA number 247 of 18, Mr. P.C. Sinha, for the appellant, Mr. Manish Kumar, for the respondent.
My lords, in this case, I was directed to seek instruction, my lords, and I have been instructed to seek one more indulgence of this honorable court, my lords. 1 week time may kindly be granted in this case, my lords.
Why? What instruction?
My lord, I was directed to seek instructions so that the matter can be settled for 15 lakh and odd, my lords. The person was on leave, my lords. He is joining only tomorrow. I just now talked to him, my lords.
Mr.
1 week
Manish,
time.
for 1 week's time. They are allowed this case after 1 week under the same heading.
Date on 22nd, otherwise it will go out of reach. It can be settled in Lok Adalat, my lords. I have received instruction to that effect, my lords.
When is the Lok Adalat?
12th March, my lords. So let it come on 22nd of February.
It will come after 1 week.
My lords.
Under the heading for admission, serial number 22, MA number 563 of 15, Mr. Vijay Shankar Jha, Mr. Manish Kumar, for the appellant.
May please Lordship, I come for the part order, my lord, regarding the only for interest part, my lord. Earlier it was heard, my lord, and Mr. Tiwari has taken time, my lord. I based on, my lord, an apex court judgment, my lord, TB Sarabi judgment, my lord, in which, my lord, it is clear, my lord, by
What is the reference of the judgments?
my lord, I am para 20. 4, my lord, and 20. In our view, both the tribunal.
What is the reference of that judgment? Give me the reference of that judgment.
2009, my lord, SEJ 2000444, my lord.
What is the parallel judgment? SCC.
2009 SSC, my lord. SSC, 2009 7 SSC 372, my lord.
2009 volume 7 SCC page
372, my lord.
372. 97372.
Para 24 and 25, my lord. Earlier it was heard, my lord, and detailed order has been passed, but Mr. Tiwari has taken time, my lord. Order may be heard, my lord, on 30/20, my lord. The appeal has been referred so and so on amount as the learned tribunal has not granted interest in view of the judgment passed in the Honorable Apex Court in case of T.P. Sarabi and others versus
LCM.
Union of India, 2009 SSC 72, my lord, 7372, my lord. Paragraph 38 also, my lord.
Where is Mr. Tiwari?
May I please, Lordship, in this matter we are appearing. Serial
Yes.
number 22, my lord, for railways.
What is the
My
case
lord,
number?
date of 12/3/1, my lord.
When did you file the application? When did you file the application?
My lord, application filed on 8/3/2002, my lord. Decided on 21/5/15, my lord. And payment was made, my lord, 19/10/15, my lord. Without interest, any interest, my lord.
No, just a minute. So this case was originally filed at New Delhi.
My lord.
This case was originally filed at New Delhi.
My lord. My lord, date of accident 12/3/2001, my lord. Claim petition filed.
Wait for a minute.
My lord.
When was the Ranchi bench of Railway Claims Tribunal constituted?
Here, my lord, it has also come in the impugned order, my lord.
Yes.
Old case number, my lord. Page 18, my lord.
Is what is the old case number?
18, my lord. First page of impugned order, my lord.
First page
Or
of
last page after the certificate, my lord.
Which page?
Page 18, my lord.
Page 18.
Impugned order, my lord. First page.
Yes.
My lord. Case number so and so, my lord. It has case number TAURNC 2002, my lord. और यही रजिस्ट्रेशन का डेट है उधर.
Old case number?
ओल्ड केस नंबर है इसमें 30045/2003।
So how are you saying that this case was filed in 2002?
वो हमको लगता है हुजूर कि पटना में फाइल हुआ होगा पहला, वहां से ट्रांसफर हुआ होगा हुजूर। ये जो
It was
12/3
It was filed in 2003. It was filed in 2003.
यस मैडम, नहीं 2002 में यहाँ आ गया है हुजूर। तीन में यहाँ रजिस्ट्रेशन इसका किए होंगे ये।
No, it was registered in 2003, but it was transferred in 2006. It was transferred in the year 2006. 30/10/2006. Yes, Swiss for the railways.
Yes, my lord, we appear in this matter, my lord, on behalf of the railways, my lord. In this matter, my lord, the appellant has confined their prayer only to the extent of payment of the interest, my lord. And it is very surprising, my lord, that you also will observe that in the order itself, the impugn order itself, my lord,
yes,
the internal page 7, my lord, which says order that the claim application is allowed on contest without interest and
Why?
cost.
Why? Why? What is the reason?
That is there, my lord. Reason has not been assigned by the learned tribunal. At least there should be some finding as to why the interest has been denied to the appellant, my lord. Either there was some latches on the part of the appellant, they have made delay in examining the evidences or something. There was.
So now you address on the main issue. You address this court on the issue.
My lord, when it comes to the my lord, factual aspects of this matter, my lord, it is not in dispute, my lord. We have accepted the award passed by the London Tribunal and we have made the entire payment, my lord. As per the order.
Why is not entitled for interest? Why this appellant is not entitled for interest?
My lord, for that a thorough examination of the entire lower court record is required, my lord, to see whether the delay.
What time you argue?
लोअर कोर्ट का रिकॉर्ड रिसीव हो गया है हुजूर, बिफोर 2 months और 3 months, my lord.
Because, my lord, this claim was filed in the year 2003, my lord, and the judgment has been pronounced in 2015. Now it has to be seen that the delay in passing of this judgment has to be attributed to which party, my lord. Whether there was a delay on the part of the railway authority or whether the appellant they themselves willingly delayed this matter, my lord.
My lord, apex court especially speaks, my lord, in our view.
Just a minute, not like this is not in this manner a case is argued. You first finish your argument, Mr. Jha.
My lord, maybe consider the apex court judgment, my lord. In view of apex judgment, my lord, the appellant is para 24 and 25, my lord.
Yes, read that.
My lord, 24. In our view, both the tribunals as also the High Court were wrong in not granting any interest whatsoever to the appellants, except by way of default clause, which is contrary to the established principles relating to the payment of interest on money claims. We therefore allow the appeal and modify the order of High Court dated 24/5/7, affirming that the order of the trial court and direct that the awarded sum will carry interest at the rate of 6% simple interest per annum from the date of the application till the date of award, and thereafter at the rate of 9% per annum till the date of actual payment of the same, my lord.
So where is the law? What is the law?
And my lord, the brief of the case, my lord, it is para 23. In the instance case, the claim of the compensation occurred on 30 November.
Just a minute.
November.
Just a minute. You are reading which judgment?
TP Sarabi judgment, my lord.
Yes, sir.
TP Sarabhai judgment.
2009 SSC 342.
Paragraph. You are reading from which paragraph? Yes. Which paragraph you are reading? I am asking you.
My lord, para 17, my lord, also speaks, my lord, the court are consistent in the view that normally when a money degree is passed, it is most essential that interest be granted for the period during which the money was due, but could not be utilized by the person in whose favor an
I don't
order
know which
of
paragraph you are reading. It is not matching with the paragraph, the book which I am having. This is, you are reading paragraph?
Paragraph, now reading, my lord, paragraph 17, my lord.
The courts are consistent.
My lord.
That is paragraph 26 of the SCC. Yes, read.
Which the money was due, but could not be utilized by the person and whose favor an order of recovery of money was passed, as has been frequently explained by this court and various high courts. Interest is essentially a compensation payable on account of denial of right to utilize the money due, which has been in fact utilized by the person withholding the same. Accordingly, payment of interest follows as a matter of course when a money degree is passed. The only question when it is such interest payable on such a degree, those there are two divergent view on indicating the interest in payable from the date when claim for the principal sum is made, namely the date of institution of the proceeding till the recovery of the amount. The other view is that such interest is payable only when a determination is made and order is passed for recovery of the dues. However, more consistent view has been the former, and in rare cases interest has been awarded for periods even prior to the institution of proceeding for recovery of the dues, where the same is provided for by the terms of the agreement entered into between the parties, or where the same is permissible by statute. Next, my love, para 19. Accordingly, we are unable to sustain to the order of Railway Claim Tribunal directing payment of interest on default of the payment of the principal sum within a period of 40 days. As we have indicated herein before, when there is no specific provision for grant of interest on any amount due, the court and even tribunal have been held to be entitled to award interest in their discretion under the provision of Section 3 of the Interest Act and Section 34 of the Civil Procedure Code. And my lord, lastly, my lord, para 24 and 25, my lord, the allow. And in this case, my lord, the appeal is allowed to the aforesaid extent the respondent shall pay the cost of this proceeding to the appellants assessed as rupees 25,000.
That is all. Yes, respondents.
Yes, my lord. Yes, my lord. My lord, after passing of this judgment now, my lord, I would very fairly submit, my lord, now the law is settled. As there is no provision under the Railways Act, my lord will see paragraph 13 of the same judgment. Perhaps, my lord, I'm extremely sorry. This is also not an SCC, my lord, but your lordship can gather paragraph 13. Admittedly, neither the railway may be permitted to read, my lord.
Paragraph.
And
Yes.
my lord, admittedly,
Yes.
neither the Railway Claim Tribunals Act 1987 nor the Railways Act 1989 makes provision for payment of interest on any awarded amount. While Section 16 of the 1987 Act prescribes the procedure for making an application to the claim tribunal, the right to receive compensation is contained in Section 124 and 124A, comprising Section 13, Chapter 13 of 1987 Act, dealing with the liability of the railway administration for death or injury to the passengers due to accident. Even though there is no provision in either of the acts for payment of the interest on the awarded sum, there is no denying the fact that the right to claim compensation occurred on the date of incident. Although compensation has been held in Rati Mena's case, supra is to be computed from the date of award of the claim tribunal. In case where the statute does not make any specific provision for payment of interest or on any awarded sum, the power of the court to grant interest can also be referred to from the provision of Interest Act 1978 and the Code of Civil Procedure, Section 3 and Section 3 of the Interest Act, which affirms power of the court to allow interest reading as follows, my lord. May I read this one as well, my lord?
No, no. Read. This is the section 3 was quoted here.
Yes, my lord. It has very specifically stated here that although there is no provision in the Railways Act or Railway Claim Tribunal for payment of any interest, but this is the usual procedure followed by the courts and tribunals to award interest along from the date of application till the date of award, my lord. This is there, my lord, and the concluding paragraphs, my lord. Now, my lord, this judgment is prevailing. I would fairly submit, my lord. Thereafter, there is no further judgment, and this is what the learned tribunal is dealing with, and Honorable High Court has also held in many of the judgments that usually 6% of interest to be given to the claimant from the date of application till the date of award, my lord. This I admit, my lord. But my lord, while passing an order for payment of interest, my lord, it has to be seen that they are entitled for interest, because there is a practice of lingering matters for years and years so that they can get a hefty amount of interest.
Matter was lingered for the fault of the claimant. The delay is attributable to the claimant. You show me any document. There is nothing on record. In
Yes, my lord,
2003, it was filed. 2006, it was transferred to Ranchi.
Yes, my lord,
In
certainly.
2010, you have filed your written statement. This clearly suggests that delay was in your part. Look here. Heard the
My
counsel
lord,
for the applicants.
just may I submit, my lord.
Yes.
One indulgence may be given so that I could inspect the lower court record, because I'm not having it with me, my lord.
After hearing everything, in that case, I will not delay this matter.
Then,
It's unnecessary. Unnecessary lingering the litigation.
no, I'm not praying for much time, my lord. Only
Heard,
indulgence may be.
heard the counsel for the appellants, heard the counsel appearing on behalf of the respondents. A limited prayer has been made in this appeal, whereby a part of the award asked by the Railway Claims Tribunal in case number so and so dated so and so has been challenged by the appellants. First time. The appellant is aggrieved by the portion of the award which rejects the uh, portion of the award by which interest has not been awarded on the amount of compensation, assessed by the tribunal. Next part. The dispute is very limited in this appeal, full stop. Admittedly, the tribunal, by the award dated so and so, has held that the appellant or the claimants are entitled to get compensation amounting to rupees 4 lakhs. While after allowing compensation, the tribunal has held that the claimants are not entitled for any, has held that the tribunal did not grant any interest. Full stop. Next part. The counsel for the appellant submits that the tribunal has power to grant interest. He submits that without assigning any reason, the interest has without assigning any reason, the tribunal has disallowed interest on the amount of compensation. He submits that while denying the interest component, it was incumbent upon the tribunal to assign a valid reason. He submits that in absence of any reasons, this part of the award by which the interest was not granted is bad. Full stop. Next para. The counsel appearing on behalf of the railways submit that the tribunal has allowed the claim application but without interest. He submits that it was the fault of the appellant as they delayed the entire proceeding, and thus they are entitled to receive interest. First, after hearing the parties, I have gone through the award and the lower court record. Full stop. The issue in this appeal is only restricted to the payment of interest. Thus, I am not entering into the other merits of the case in relation to the accident and the accident, liability and entitlements to receive the compensation. Next paragraph. The issue of payment of interest in a claim application filed before the Railway Claims Tribunal has been set at rest by the Honorable Supreme Court in the case of so-and-so versus so-and-so as reported in 2009, Volume 7, SCC, page 372. Full stop. The The Railway Claims Tribunal Act of 1987 nor the Railways Act of 1989 make any provision for payment of interest on any awarded amounts. Full stop. Considering the aforesaid provision of law, the Honorable Supreme Court in the judgment of so-and-so Supra has held that Section 3 of the Interest Act and Section 34 of the Civil Procedure Code gives the power to grant interest. The Honorable Supreme Court has held that in cases where statute does not make any specific provision for payment of interest on any awarded sum, the courts can derive power and grant interest by invoking the interest provisions of the Interest Act and the Civil Procedure Code. Full stop. It is necessary in this context, it is necessary to quote paragraph 21 of the aforesaid judgment. Paragraph 21, isn't it? Quote. Paragraph 21 and paragraph 30. No, paragraph 20 or 30 it's a repetition. Next para. An interest is paid as a person who is entitled to receive a monetary benefit is deprived from using the said is deprived from the fruits of the said is deprived by from the fruits of the said benefits as the money is withheld by by a person who is supposed to pay the same. Full stop. Since the money which is being withheld is utilized by the person who has withhold the same, comma. So when he is directed to pay the amount, he should also pay interest. Full stop. This interest is by way of a compensation on account of denial of the right which a person is deprived of. Good stuff. The Honorable Supreme Court in the aforesaid judgment has also held that payment of interest follows as a matter of course when a money decree is passed. Good stuff. It is necessary to quote paragraph 27. Paragraph 26 and 27 of the aforesaid judgment. Also, thus from the aforesaid finding, it is clear that even if there are no provisions of payment of interest, comma, in this case the claimants are entitled to receive interest from the railways. Next paragraph. Now the question is, now the question is from which date the claimants are entitled to receive interest, and whether there was any fault on the part of the claimants, and whether the claimants have delayed the proceeding. First time. The Honorable Supreme Court in the aforesaid judgment, next paragraph, has answered this issue in paragraph 28. And 37, which needs to be quoted. Full stop. Next paragraph. In this case, while I go through the lower court records, I find that the claim application was filed in the year 2003. Thereafter, the claim application was transferred to the Ranchi bench of the Railway Claims Tribunal on while order dated 30/10/2006 from the Patna bench. Full stop. The railways filed their written statements only on only on 3/9/2010, whereas several adjournments earlier was granted to file a statement. This fact clearly suggests that there was no fault on the part of the appellants, on part of the claimant appellants, and it is not because of them the case, the claim case got lingered. Let's stop. Considering what has been held above, no, let's go further. When I go through the impugned order, I find that the tribunal has held that has allowed the claim application on contest without interest and cost. First of all, why the appellant claimant was deprived of the interest component has not been mentioned, not been discussed, nor it is mentioned. First of all, if a claim full stop, if a claim मत लिखिएगा. In case of a money degree, comma, in terms of the judgment cited above, comma, as a matter of course, interest should be allowed. Full stop. This has been held in paragraph 27 of the aforesaid judgment. Full stop. When a relief has to be granted as a matter of course, comma, then it is a rule. Then it is a rule, and not granting the same and denying the same will be an exception. First stop. If the court wants to apply the exception, then if the tribunal wants to apply the exception, then a valid reason has to be, a reason has to be assigned as to why the normal course is not being followed. Full stop. In this case, awarding of interest, comma, at whatever rate it may, comma, is the normal course. Full stop. When the court has deviated from this normal course, it was incumbent upon the tribunal. When the tribunal has deviated from the normal course, it was incumbent upon the tribunal to give reasons, which is missing in this case. Thus, the part of the award by which the interest has not been granted, comma, without assigning any reason, lacks the test of reasonableness, and thus cannot be accepted. Full stop. Next paragraph. Considering what has been held above, this court is of the view that the claimant, this court directs the respondent. This court holds. I hold. Considering what has been discussed above, I hold that the claimants are entitled for interest from the date of filing of the application before the Railway Claims Tribunal till when was the amount paid? When was the amount paid to you, Mr. Counsel?
I got on two dates, 19/10/15 and 7/12/15.
7/12/15 my lord.
Why 7/12/15? And the other one?
The first one 19/10/15 and the second one 7/12/15, my lord.
1910 till the amount was paid on 19/10/2015 at the rate of 7% per annum. This payment should be made within 2 months from today. This appeal is allowed.
I may be permitted to submit something, my lord.
Yes.
Oblige, my
My lord, the judgment which has been relied by my learned friend and your lordship has also taken consideration of. In that judgment also, my lord, 6% interest has been allowed to the appellant.
That was long back. Now 6% is nothing. What is the
Oblige, my lord.
what is the rate of current rates? Tell me, what is the current rate of lending? It is much more. It is much more.
Certainly, my lord, certainly. And my lord, may I pray one more thing, my lord, please? My lord, name of Mr. Mahesh Tiwari he is the arguing counsel for railways, my lord.
Sorry, Mr. Ankur. This entire proceeding is a live proceeding which is being recorded and seen by everyone. How can I put in a name of a person who has not even appeared?
We will be appearing, my lord, because on board today there are many cases, my lord, under the headings for.
Now you people have to manage and give priority. If you want that the name of a lawyer should be recorded, he should mark his presence before this court, at least the court in which the proceedings are live streamed. I can't help it. Yes.
I'll take care of my.
And convey this to all, not only in your chamber, convey this to all the lawyers, all your fellow lawyers. Yes.
MA number 23, MA number 585 of 15, Mr. K. Oja.
I am on behalf of the appellant, my lord.
Yes.
Application for restoration of IA 828/2016 has filed.
Restore.
Oblige.
Restore against whom? Restore.
Sorry?
Restore means restore against whom?
For limitation petition I 828/16. That was the limitation petition, my
That
lord.
was dismissed. That was dismissed. 828 is dismissed. 828, your IA number 828 is of 2016 also stand dismissed. So your this appeal was dismissed against respondent number 1 and 2.
Today I am filing for the restoration of the same IA petition, my lord. CMP has filed before you.
You have filed a CMP?
Yes.
What is the case number, CMP number? What is the CMP number?
Not provide me. That is not provide me.
Also, for the appellant submits that an application has been filed, a CMP has been filed to restore IA number to restore IA number 828 of 2016. Full stop. List this case along with the aforesaid CMP.
Serial number 24 with serial number 25, MA number 505 of 16, with MA number 506 of 16. Mr. DC Ghosh for appellant in both the cases, Mr. Gautam Kumar, Ms. Savita Kumari, Mr. Virat Kumar for respondent in both the cases.
In this case, my lord, under the instructions of Mr. Yasir Arafat, I am appearing on behalf of the claimants, respondent 1, 2, and 3.
My lord.
Yes, LCR. Yes, Mr. Ghosh. What is this?
In both the appeals arising out of the same accident, issue of liability is under challenge on the ground of driving license. Driving license exhibit 7, say LMB non-transport. My lord, now
this issue has been set at rest.
Yes. Therefore, because in 2008, the definition of LMB does not include the light motor vehicle.
When the judgment was passed, the judgment of the Supreme Court was not there.
Yes, my lord.
So now, if there is a license to drive an LMB, if the person is driving an LMB, be it a commercial vehicle or a non-commercial vehicle or a passenger carrying vehicle, it hardly matters.
Yes, my lord.
Now, so
that is.
Now, what is your other?
The definition of transport vehicle is in the Act, but the definition of non-transport vehicle has not been defined in the Act.
Yes.
This is the situation.
So what is the judgment of the Honorable Supreme Court?
That 2018 Volume 2 LMB includes a transport vehicle. No separate endorsement is required.
2018 Volume 2 SCC?
TAC 13, Transport and Accident Cases.
What is the name of the party?
Well, subject to my lord's convenience, these two cases, इसमें not today कर दिया जाएगा.
not today करेंगे.
तो इसन हम खाली थोड़ा सा देख लेंगे, हजूर का सबमिट कर देंगे.
कुछ नहीं. Let me see what is your ground.
उसका पार्टी का पोजीशन मेरे पास ये नेम नहीं है मेरे पास.
Let me see what is the.
Mr. Arvind Lal, it helps.
And last week also I have dictated a judgment of this line.
Yes, sir.
ये वाला है. Passenger carrying vehicle. No, not this. The passenger carrying vehicle road. Last week.
That is my lord, 2017 Volume 4 TAC, page 11.
Name of the party?
Mukund Devangan.
Yes,
versus Oriental Insurance Company Limited.
Mukund Devangan versus Oriental Insurance.
My lord.
2017 SCC होगा देखिए. Sort out करके रखिए अलग से. Yes.
And regarding the name of the party is that 2018 Volume 2, that is Jagdish Kumar versus United India.
Jagdish Kumar versus United India.
Yes, ma'am.
इसको भी लाइए.
Equivalent to 2017 Volume 14 SCC.
2017 Volume 14 SCC page?
663. That is the citation Mukunda Kumar. इसमें इसको
इसको रिलाय करके इसको बाद में दिया गया है
2017 volume 14 SEC live 8663.
same proposition
suddenly list which take away and नहीं अभी कोई list थोड़ा सा
Exhibit 7 is the photocopy
Exhibit-
of the license.
Exhibit 7 is the driving license. Copy of the driving license. Exhibit A is my investigation report,
Yes.
which has been discarded by the court below, saying that a DTO has not been examined.
It's a non-transport way.
Yes, yes. Both are same. Finding us the both are the same.
Yes, the Supreme Court holds that both are same.
Yes, yes. Thereafter, nothing remains.
Mr. Devesh Ghosh, just for the sake of knowledge, you just tell me one thing. The class of vehicle is LMV,
LMD,
and within bracket it has been mentioned NT. That means non-transport.
non-transport.
That means what are the type of vehicle which can be said to be a non-transport vehicle?
In the Motor Vehicles Act, non-transport has not been defined, but transport vehicle has been defined 247.
Like MBH. Yes.
Section 247.
2 within bracket 47. Yes. What is it?
Transport vehicle means a public service vehicle, a goods vehicle, an educational institution bus, or a private service bus. Here the vehicle is goods
So
vehicle.
now just tell me, the transport vehicle means a public service vehicle, a goods carriage vehicle also,
My lord.
an educational institution bus, or a
Or
private service bus.
private service vehicle.
Now tell me, what are the vehicle which
Public service vehicle is defined in subsection.
public service vehicle is already here. It is mentioned that it is a transport vehicle. So I'm asking you, what are the nature of vehicle which can be termed as a non-transport vehicle, that means the vehicles which you can take out of purview of this definition 347 will be a non-transport vehicle. Now, which vehicle can you take out from this definition? Will come out of the ambit of this definition.
Yes, my lord. I am also of the opinion, my lord, is just like that. Because here the service vehicle is covered, goods carriage is covered, educational institution covered, private service vehicle covered.
Yes.
And here, if it is taken, public service vehicle means a motor vehicle used or adapted to be used for the carriage of passengers for hire and reward. For hire and reward.
That is a passenger vehicle. The passenger vehicle is also included in 47.
But whether non-transport means a goods carrying vehicle.
Goods carrying vehicle is also covered. The goods carrying vehicle is also, good carriage is also covered in 247, transport vehicle.
Yes, that means
Then
non-transport means
what is not covered? What is not covered in this 247? Tell me.
a goods carriage. Everything has been covered, but a vehicle carrying goods without fare.
So what is LMV non-transport? Tell me.
LMB, that is the 1,700 below.
That is a light motor, yes. That is as per the manufacturing specification. But what is this NT? Non-transport. There is nothing called non-transport.
Nothing, my lord. I also found that. अगर goods carrying vehicle without fare लेकर के भी चलाते हैं, तो in that case, that definition of non-transport must be defined in the act.
Where this authority giving license for a road roller, for driving a road roller?
Yeah.
So by writing non-transport.
Yeah.
I fail to understand the logic.
This, इसमें Exhibit 7 में भी है, light motor vehicle non-transport.
So that is why I am asking you. I have seen from Exhibit 7. What does this non-transport mean?
Mr. Lal, whether you are, if my lord Mr. Lal, if some.
When Mr. DC goes is there. Non-transport means general ऐसे कर रहे हैं, which is not a transport vehicle, is a non-transport vehicle. But so far private transport vehicle, my lord. So far private.
Mr. Arvind Lal, what are the type of vehicle which can be said to be a non-transport vehicle?
There is no such definition under the Motor Vehicle Act.
So you cannot carve out an exception of 247 also. At best you can say the vehicles which is not covered by 247 is a non-transport vehicle.
Yes, my lord.
So,
but here all is covered, including even in private service vehicle, my lord. That is
right. Another Mr. Lal wants to throw some light. Yes, Mr. Lal.
For a moment. Yes. The Central Motor Vehicle Rules.
Yes.
1989. That is, whether it is repealed or not. Definition clause 2(8). Non-transport vehicle means a motor vehicle which is not a transport vehicle.
That means which is not covered by 447.
Yes.
Just tell me the nature of vehicle which is not covered by 447 and which needs a license. Yes, Mr. Lal, Mr. Alok Lal, unmute yourself.
The private cars
that
which are being used by the person, yes, they are the non-transport vehicles. As I've read somewhere, I'll have to search it out again. But non-transport, there is a question in this case.
What do you mean by private service vehicle?
The vehicle which belongs to the private individuals, which is being used for their personal use.
So
no, my lord. Private service vehicle definition is in section 2,
First of all, you hear what I am submitting.
Yes.
Private vehicle is the vehicle which is being used by the persons for their personal use. They will come under the category of non-transport vehicle. As I have read somewhere, I'll have to search it out again, and I'll be able to enlighten your lordship. Those non-transport vehicles are the private vehicles which are being used for personal use.
But what is the definition
of private service vehicle, my lord? In 233 means a motor vehicle constructed or adapted to carry more than 6 persons.
So then, Mr. Alok Lal, what Mr. Alok Lal is saying, that means a vehicle which carries less than 6 persons is a non-transport vehicle.
My lord.
But here the vehicle is a goods carriage, goods vehicle.
But subject to correction, but the Mukund Devangan case is also has been referred to the larger judgment in Rambha Devi case, Ballot, and it is likely to come in the second week of February before the Honorable Supreme Court for hearing.
Reference will merely referring, that doesn't mean that they
Yes,
opted.
Lord, I could not lay hand on the judgment, Your Lordship, as the reference, but I have come to know. Oh, some of my friends who are appearing in those cases. But they are
Okay,
not.
further counsel for the appellants, Mr. D.C. Ghosh, and the respective respondent counsel appearing on behalf of the respondent in both cases. एक साथ लिखिए. The common question is involved in both these appeal. Full stop. The two appeals, this two appeal arises out of two judgments, an award passed by the tribunal, Motor Accidents Claim Tribunal, Pakur, arising out of the same accident.
My lord.
Pakur. Full stop. Full stop. Both these two motor accident case being MSCT case number 39 of 14 and 41 of 14 arises out of the same accident. Full stop. It is stated that a pickup van bearing registration number JH 15 capital oblique 6668 668 was being driven rashly and negligently. Full stop. The vehicle was coming from Pakuria and dashed the deceased. That's 3-person कर दीजिए, who were standing on the side of the road and was waiting for a bus, waiting for a transport vehicle. Full stop. Okay. Munshi Marandi and Ismail Hasda died. Now, what is the other person? And Ismail Hasda died, which resulted in filing of the claim applications. Full stop. The tribunal, after considering all the issues, have awarded compensation, allowed the applications, and awarded compensation to the claimants of both the cases. Next paragraph. The insurance company has challenged the award on a limited ground, that is, the vehicle which was being, the offending vehicle was bearing number JH 15E 6668, was being driven by a person who was not authorized to drive the pickup van. First up. The counsel for the appellant submits that as per Exhibit 7, which is the driving license, the driver was authorized to drive a light motor vehicle within bracket LMV, which should be of non-transporting nature. He submits that the vehicle which was being driven by the driver was admittedly a LMV, light motor vehicle, but was a transport vehicle. Was a transport vehicle. Thus, full stop. He submits that this is a violation of the policy, as it will be deemed that the driver was driving a vehicle without a valid license. He submits that in that case, in that case, it is the owner of the vehicle who has to pay the amount of compensation. Full stop. Thus, from the argument of the counsel for the appellant, it is evident that he wants to raise a plea ground that in absence of an authorization allowing the driver to drive a transport vehicle, he is not authorized to drive the vehicle which was being driven by him, even though the vehicle was a light motor vehicle. Next. The question as to whether, in absence of any authorization to drive a transport vehicle, a driver can drive light goods public transport vehicle as per law, has now been set at rest by the Honorable Supreme Court in the case of Mukund Devgan versus Oriental Insurance Company so-and-so, as reported in 2016, Volume 4 SCC, page 298, first up. The said judgment has been followed and reiterated by the Honorable Supreme Court in the case of Jagdish Kumar Sood versus United India Insurance, which is reported in 2018, Volume 3 SCC, page 697. First up. The Honorable Supreme Court in the case of Mukund Devgan has decided the issue in paragraph 60.1 and 60.2. It would be necessary to quote the aforesaid paragraphs. Quote, considering the position of law which has been set at rest by the Honorable Supreme Court, I hold that the driver who was driving the offending vehicle bearing GH 156668 was duly authorized to drive the pickup van. Full stop. Next paragraph. Thus, I find no illegality in the judgment passed by the tribunal in both the cases whereby insurance company has been saddled with the liability to pay the amount of compensation. Both these appeals thus dismissed.
The statutory deposit, my lord.
The statutory deposit which has been deposited before this court by the insurance company at the time of filing this appeal should be refunded to the insurance company.
In this case, my lord, since I am representing Mr. Yasir Arafat, so therefore my name may be recorded in the top of this.
You said your appearance slip.
My lord.
Appearance slip should be there.
My lord.
Yes.
My lords, item number 26 I am appearing for the appellant, my lords.
Yes.
सुनाई ही नहीं दिया, केस कॉल हो गया, पता ही नहीं चला. My lord,
There are some technical issues.
my lord.
Yes.
In this case, my lord, there are two grounds, my lord. First ground is that, my lords, the claimant filed the case in 2009, and first time notice was issued to the insurance company in 2014, my lords. And interest has been given from the date of filing of application at the rate of 9%. This is the first ground. And second ground is that, my lords, the claimant injured was, my lord, traveling in a goods carrying vehicle as gratuitous passenger. This plea was specifically taken, and no specific issue was framed, but it was framed that whether the insurance company entitled for right of recovery or not. And it was held that since driver was in possession of valid driving license, therefore no right of recovery can be granted. Whereas the issue was whether the, my lords, a goods carrying vehicle can carry passengers. From the FIR as well as from the claim petition, it is clear that, my lords,
LCR.
LCR was called for on the last day, on 6 months.
Earlier, I am for the claimant or lordship. Earlier, LCR was called for lordship. Earlier occasion, lordship, LCR was called for lordship.
Who is for the owner?
Dated 6
I'm
12
appearing on that.
2021.
Yes. Yes, Mr. Manish Kumar, let's see how you
Yes.
substantiate your
My lords, you see the claim application itself, my lords.
claim application.
Yes, my lord.
Let us see.
At paragraph 20, my lords, page number 4 of the claim application.
Just a minute, let me see. Paragraph 20. It's in Hindi.
Yes, my lords, Hindi.
Read that.
दिनांक 9/5/2007 को आवेदक अमानत अली करीब 6:45 बजे तिलैया थाने अजमत अली करीब 6:45 बजे तिलैया थाने के लिए ग्राम तारा नाखो में अपने साथी मोहम्मद अताउल्ला के साथ टेम्पो नंबर JH02H5645 में सवार हुआ। अरखांगो गांव के निकट पलट गई, जिससे आवेदक को गंभीर जख्म हुआ। आवेदक का बायां पांव टूट गया, जिससे आवेदक का शारीरिक मानसिक आर्थिक नुकसान हुआ। This. So, my lords, he himself said that he.
So tempo, how do you say that it's a commercial vehicle?
I have annexed the insurance policy, which was exhibited before the court below also. My lords will kindly come to my memo of appeal. It is there, it's easy to find. Page number 22 of my memo of appeal.
I will not see a memo. I see the exhibits.
Yes, my lord. It is. I am placing that exhibit, my lords.
And now let me see your rebuttal. What is your stand?
My lords. My lords will see exhibit X is the insurance policy. First, my lords will kindly see for a moment. Exhibit X, marked as X for identification.
Yes.
My lords, on the top right side, my lords will kindly see package policy, goods carrying commercial vehicle.
Next, sir.
It is marked as X, my lord, for identification before the trial court. It is annexure 3 to my memo of appeal also. Page number 22 of my memo of appeal also.
Just a minute. Oriental Insurance Company.
Yes, my lord. And just below that, policy type.
Package policy.
Yes, and thereafter, my lord, goods carrying commercial vehicle.
Yes, goods carrying commercial vehicle.
Yes. Now, exhibit 6, my lords, FIR.
Come to the evidence.
My lords.
Come to the evidence of the claimant. This is a case of injury.
Yes, this is a case of injury, my lords. Evidence I'll have to, my lords, obtain from the court, my lords. Then it may kindly be placed in the physical court, my lords. I'll note down.
Why should I unnecessarily adjourn this case?
My lords, this is his claim. From the very beginning, he is saying that he boarded that vehicle as passenger. Exhibit was, insurance policy was exhibited. FIR also says the same thing, that he boarded the vehicle as passenger. It is not his claim that he was riding the vehicle as owner of goods or an employee of insured. It was never his case. We have taken specific stand that, my lords, the Tata Ace Tempo number such and such was overloaded and claimant is a gratuitous passenger. Hence, there is violation of terms and conditions of the policy. It was writ large on the face of it, my lords. Issue number 7 was filed to the effect that whether the insurance company has got the right to recover the amount of compensation, and that was decided along with 5 and 6. 5 and 6 were related to, my lords, contributory negligence and all the vehicular documents.
Okay.
Without discussing that he was a gratuitous passenger, it was held that there was valid permit, valid driver license, therefore.
What right of recovery was not given.
Yes, my lords.
You are praying for right of recovery.
And yes, my lords, and from interest, my lord.
Just right of recovery, what are the judgments you are relying upon?
I am relying upon, my lords. Munawara Khatun judgment is there where gratuitous passenger, when gratuitous passenger is there, even in such cases, insurance company will only get right of recovery.
Where is that judgment? Give the reference.
My lords, I'll give the reference, my lords.
Yes, now, yes, send it. Now, on your second issue, the interest.
Yes, because notice was issued to me.
Application.
Yes, notice was issued to me in 2014.
Case was filed when?
2009.
February 9.
You are respondent number?
I am, my lords, respondent number. Here it is mentioned as 16.
16?
I have got the, my lords, copy of the notice also.
Yes, you were?
It is mentioned as, my lords, in the impugned order, it is mentioned as 16. I don't know why, my lords. But in the I have got the copy of the summon, my lords. It was given to me on 11/2/2014, issued on 11/2/2014.
Who was OP 1 and 2?
From the claim petition, it.
AIUs.
Oh, 15, 16, 18. What is 15, 16, 18? There are only
Yes,
three opposite parties. How the
Yes,
number
ma'am.
made 15, 16, 18?
This is, my lords.
There are only three parties. Oh, that is in the column. That is why. Malik ka naam pata. It's ridiculous.
Yes, I have got the copy of summons, my lords, on which the issuing date is mentioned as 11/2/2014, mentioning that next date is 2nd August 2014.
Mr. Deepak Kumar, there was negligence on your part in respect of issuance of notice from the respondent.
He
Insurance.
is for the owner, my lords.
No, sorry, the claimant.
Sudhir Roy.
The claimant. Yes, Mr. Roy. Mr. Sudhir Roy. There was
Yes, sir,
negligence
Lord.
on, there was negligence on your part. You file the requisites in a wrong, incomplete address. Then the court passes an order that you correct the wrong. You file a fresh notice, or you at least you file a notice with in the correct address, or you rectify the address. You don't do it. The matter gets adjourned for this. Don't rectify the notice. Then this you who have delayed the matter till 2014. Then
Notice was issued.
tell me. You are prima facie, this court is of the opinion that you are not entitled to get interest from the date of filing.
इसमें जो नोटिस तो अर्लियर भी इशू किया गया था लॉर्डशिप.
Yes.
Earlier notice was issued, lordship.
What? Notice issued to whom? Are you following the argument of Mr. Manish Kumar? Have you followed what he is trying to say?
Lordship.
Yes.
जजमेंट में ये चीज तो नहीं जो दिख रहा है नोटिस वाला
What do you have to argue? Tell me.
Lordship.
Yes, you argue on this part.
नोटिस तो भी रहा हमको ये 2014 इनको फर्स्ट टाइम नोटिस मिला है
So he is
whether
saying
case has been filed on 2009
he has received the
it is not
notice.
clear from the judgment Lordship I know.
Yes, he says that he has received the notice in 2014, so the interest is paid.
2014.
14. What do you have to say?
Whether case has been filed in 2009 Lordship. Case was filed 2009 Lordship.
So if you delay service of notice, then what will happen?
इसको वेरीफाई करने के बाद ही क्लियर हो पाएगा लॉर्डशिप ये किनके तरफ से लचेज हुआ है लॉर्डशिप
Yes. Case was filed in 2009.
Yes, my lord.
From September 2010 to September 2013, you are not entitled to for any interest for 3 years. You have delayed and have not complied the order which was passed. So for 3 years, you are not entitled for interest, Mr. Roy. Yes. What do you have to say? Yes, Mr. Roy, what do you have to say? For 3 years, you are not entitled to receive any interest.
19 to 13.
From 10 to 13. From 2010 to 2013. September 2010 to September 2013, that means 3 years.
लिखा दिया जाए जो रीजन असाइन करते हुए।
तो हम तो रीजन असाइन करते हुए लिखा है। What do you think? It will be without reason. What do you have to say? I'm asking him.
इसमें जो 40% डिसेबल यूजर हो चुके हैं और
No one is challenging the quantum. You have nothing to say.
तो इसको जो एक बार वेरीफाई लॉर्डशिप कर लेते हैं यार, ये कुछ डेट में भी।
Why should I grant it unnecessary? After hearing everything.
2014 में जो इनका कहना है कि 2014 में हमको नोटिस इशू हुआ फर्स्ट टाइम में।
हम 14 से नहीं, हम बोल रहे हैं कि the court has granted interest from 2009 to 2000
till
the payment is made.
Yes,
But from the period 16/9/2010 to 21/9/2013, you are not entitled for interest for this period because it was your laches. So from date of filing till 16/9/2010, that is for 1 year you are entitled. You filed this case when? To 2009. So 1.5 years there, and then after September 2013 you are entitled for.
Lordship.
Yes, Mr. Deepak Kumar, on the second issue.
Lordship.
What do you have to say?
My lords, it is apparent that the petitioner, the claimant was, my lords, a mason. Although there is no material on the record that he had proceeded with his goods, my lords, over the tempo.
But he was a passenger.
Yes.
So then you have to, he has, the insurance company will have a right to recover the amount from you. Heard the counsel for the appellant and heard the counsel for the respondents.
My lord, the judgment, my lords was asking me, my lords, 2017, volume 4.
2017, volume 4.
SCC.
Just a minute. 2017, volume 4, SCC.
796, my lords.
796.
Paragraph number 21 and 22.
21, 22. You heard the counsel for the respondents. Full stop. Next paragraph. This appeal has been filed by the insurance company challenging a part of the judgment and award passed by the Motor Accidents Claim Tribunal number so and so dated so and so. Next paragraph. The learned counsel appearing on behalf of the appellant has raised only 2 grounds in this appeal. He submits that the right to recover the amount of compensation should have been granted to the insurance company as there is a violation of policy. The vehicle which met with an accident, resulting in injury of the claimant, is admittedly a goods-carrying vehicle. So he submits that from the evidence and the materials on record, it is clear that the injured claimant was traveling as a passenger in the goods-carrying vehicle. That being so, the liability should be fastened upon the owner of the vehicle to pay the amount of compensation. So he submits that this aforesaid issue has not been decided at all, not been considered and decided at all by the tribunal. Thus, the legitimate right of the insurance company, to recover the amount from the owner was not granted. The second ground which has been raised by the insurance company is that the insurance company has received the summon to appear before the tribunal, received the summon on, give me the date.
It was not date of receipt, not the date of issuance, either 11/2/2014.
Received summon which was dated 11/2/2014. Thus they are not thus the interest should not have been directed to be paid from the date of filing of the claim application, that is 18/2/2009. He submits that at best the insurance company could have been directed to pay the amount of interest from February 2014. He submits that the notice which was issued in February 2014 clearly suggests that there was delay on the part of the claimants in pursuing this claim, and thus they are not entitled to receive interest from the date of filing of the case. That's our next paragraph. The counsel appearing on behalf of the claimant submit that that he has got no objection if the insurance company is given the right to recover the amount from the owner. He submits that even if there is a violation of the policy and the claimant was a gratuitous passenger in a goods carrying vehicle, the primary duty is upon the insurance company to satisfy the award and thereafter proceed against the owner of the vehicle to recover the said amount. Next one. So far as the question of interest is concerned, he submits that the claim application was filed on 18/2/2009, and thus the interest was granted from the aforesaid date, and no fault can be found in the judgment passed by the tribunal. He submits that there was no laches on part of the claimants in pursuing this appeal. Full stop. Next paragraph. The counsel appearing on behalf of the owner of the vehicle submits that, yes, Mr. Deepak Kumar, what will I dictate?
Well, it's because the injured was traveling with goods, my lords.
Submits that since the injured was traveling with goods in the goods carrying vehicle, it will be goods carrying vehicle. It is the insurance company who has to pay the amount, as admittedly the vehicle was duly insured by the insurance company. He submits that being an owner of the goods, he is entitled to travel in the goods carrying vehicle along with his good. And as an owner of the good, as the owner of the good was traveling along with the goods, the owner of the vehicle should not be saddled with the liability to pay the compensation, when admittedly the vehicle was insured. Admittedly, his vehicle was insured. After hearing the parties, I have gone through the impugned judgment and the lower court record. Full stop. The quantum is not under challenge. Full stop. The factum of accident is also not under challenge. Considering that the aforesaid issues are not under challenge, I am not entering into those issues. I am not entering into those issues. Full stop. This judge, full stop. Since a limited challenge has been thrown to the award, only the challenge which are thrown is being dealt hereinafter. Let's stop. Next panel. The first ground which the insurance company has taken is that the offending vehicle being a goods carrying vehicle, and the injured was a gratuitous passenger. Thus, the right to recovery should have been given to the insurance company to recover the amounts from the owner of the vehicle. First stop. To appreciate this issue, I have gone through the claim application. First stop. In the claim application, the claimant, in paragraph 20, has described the manner how the accident has taken place. First up, he has stated that on 9/5/2007, the claimant at about 5:45, the claimant at about 5:45 शाम की सुबह
6:45, my lord. Just a moment, my lord. I'll give you it from the FIR. Just a moment. रात शाम क्या बात है, my lord?
Evening.
क्योंकि FIR रात को 8 बजे हुआ है.
Along with his associate. After paying higher charges, traveled in the offending vehicle number J802H5645. Full stop. While the vehicle reached near Arkhango, which is the place?
Arkhango, my lords.
Arkhango village. The vehicle turned turtle, as a result of which the claimant sustained injuries. His left leg got fractured, and he also sustained other physical damages. He was not in a position to work for 1 year, thus sustained huge pecuniary loss. First one. Further, the FIR has been exhibited, which is exhibit number
6, my lord.
6. The FIR has been exhibited again. The first information report, which was registered due to the as a result of the accident. Full stop. As per the FIR, I find that the author of the FIR, Fadbia, stated that on 9/5/2017, author is who?
He himself, Bimal Sajmat Ali.
Informants,
He
along
himself.
with his associate, boarded a tempo to go to Tilaiya. Further, it was mentioned that but later on, the driver overloaded the tempo with passengers as a result of which the tempo turned turtle, resulting in injury. Full stop. Evidence of the claimant. The claimant was examined as witness number 1. In his evidence also, he has stated that he was returning to Telaya. He wanted to go to Telaya. He sat on a tempo, which is the offending vehicle. And the driver allowed other passengers to sit, and as a result of which the vehicle turned turtle and an accident has occurred. From the aforesaid facts, which has been narrated by the claimant himself in his claim petition, in the FIR and his statement while deposing as a witness, nowhere he states that he was a passenger of the vehicle along with his goods. From the statement, it is clear that he boarded the tempo as a passenger. This statement clearly suggests that the vehicle was being used as a passenger carrying vehicle, as it is evident that the claimant himself has accepted that after he boarded the vehicle, there are several persons who also boarded the same. Now the question is, what is the category of this vehicle? The insurance policy has been brought on record, which was marked Exhibit X for identification before the tribunal. Full stop. This insurance policy has been relied upon by the tribunal and by the parties also. Full stop. Finding this insurance to be valid, the tribunal directed the insurance, settled the liability upon the insurance company. Thus, this document, which is marked as Exhibit X, is an admitted document, and no one disputes the same. First up. When I go through this document, I find that this policy is for a goods carrying commercial vehicle. Within bracket, other than three-wheeler. Be it pertinent to mention that the vehicle which met with an accident was a four-wheeler vehicle, four-wheeler tempo. Full stop. Thus, from the insurance policy, it is quite clear that the vehicle which met with an accident is a goods carrying vehicle. Full stop. Next paragraph. From what has been discussed above, the only conclusion which can be reached is that a goods carrying vehicle was being used as a passenger carrying vehicle. So this is a violation of the policy. Full stop. Now, the question which falls for consideration is, when there is a violation of the policy and a passenger is being carried in a goods carrying vehicle and is a gratuitous passenger, what would be the consequence and who would be directed to pay the amount of compensation? First of this issue has been, it will be governed by the judgment of the Honorable Supreme Court in the case of Manwara Khatun and others versus so-and-so, as reported in 2017, Volume 4 STC, page 7796. First up. The Honorable Supreme Court in the aforesaid judgment has held that in these type of cases, it is the insurer who has to satisfy the award, and the principle of, within inverted comma, pay and recover is applicable. It is necessary to quote paragraph 15 of the aforesaid judgment. First up, quote. First up. Thus, applying the same principle which has been laid down by the Honorable Supreme Court, I hold that there was a violation of the insurance policy and the claimant was a gratuitous passenger. Full stop. In that scenario, the insurance company has got a right to recover the said amount of compensation, comma, directed to be paid, comma, from the owner of the vehicle. Full stop. The aforesaid issue was also raised by the insurance company before the tribunal, but the tribunal passed the award ignoring the same. Thus, in this case, the insurance company is entitled to recover the amount from the owner of the vehicle. Full stop. Next one. So far as the challenge in respect of payment of interest is concerned, so I find that the claim application from the lower courts, I find from the record of the lower court, I find that record of the tribunal, from the record of the tribunal, I find that the claim application was filed on 18/2/2009. First time. Notices were served, but the notices were issued, but was not served upon the insurance company. Considering the service report, the tribunal on 16/9/2010 directed the claimants to file fresh requisites and take steps for service of notice upon the insurance company. Full stop. Thereafter, the steps were taken and the requisites were filed, but there was error in such filing. Full stop. The tribunal thereafter on repeated occasions directed the claimants to rectify the notice, but the same was not rectified. First up, it was kept pending for long, and only on 21/9/2013, the claimant rectified and filed a proper notice. Thus, I find that for 3 years, that is from 16/9/2010 to 21/9/2013, the case got delayed just because of the laches of the claimant. Thus, this court is of the opinion, this court is of the view that the claimants are not entitled for interest from 16/9/2010 till 21/9/2013, that is for a period of 3 years. 3 years. The claimants are thus entitled to interest from 18 to 2009 till 15/9/2010, and thereafter again from 29/9/2013 onwards till the amount is paid. Full stop. This interest should also be calculated by the insurance company. You have not paid the amount, Mrs.
No, my lords.
Full stop. Next further, what has been held above, this appeal stands allowed. This appeal at the behest of the insurance company stands allowed. Full stop. The amount of compensation should be paid by the insurance company, which the insurance company will be at liberty to recover by a due process of law from the owner of the vehicle. But so further, the amount of compensation will carry an interest at the rate so fixed by as has been fixed by the tribunal in the award, which will be calculated from the date of filing, that is 18 to 2009 till 15/9/2010, and then again for the period 21/9/2013 till the amount is paid.
Statutory amount, my lords.
The statutory amount deposited by the insurance company at the time of filing of this appeal should be refunded to the insurance company.
इसमें वो डायरेक्शन हुजूर कब तक के लिए दे दिया जाए हुजूर, कब तक करेंगे पेमेंट लॉर्ड?
It is expected that the amount ऊपर में लिखेगा. It is expected that the amount should be paid within a period of 6 weeks. 6 weeks from today.
Offline.
Offline.